About 100 years ago, on 18th March 1922, I, Mahatma Gandhi, faced a trial in Sessions Court in Ahmedabad. The charge against me was of bringing or attempting to excite disaffection towards His Majesty's government established by law in British India. Now, Section 124A of the Indian Penal Code, a criminal code drafted and enacted by the British colonial government about half a century before this trial, criminalized any speech that incited or attempted to incite disaffection against the government. Now, during this trial, even as I plead guilty of the offense, I strongly expressed my criticism against Section 124A. According to me, this section was the prince among the political sections of the Indian Penal Code, designed to suppress the liberty of the citizens. In my speech at that trial, I rightly stated that affection cannot be manufactured or regulated by law. If one has no affection for a person or system, one should be free to give the fullest expression to his disaffection, so long as he does not contemplate, promote, or incite to violence. The British government in India had brutally used this law to suppress the emerging anti-colonial movement in India. Now, the offense was non-bailable, carried a sentence of up to life imprisonment, and was used against a number of prominent anti-colonial and nationalist figures in India in response to their written or verbal speech. Now, ironically, this colonial relic, which has at its foundation the belief that people are obligated to feel affection towards the government or else they'll be punished, continued to thrive in number of post-colonial states. Now, the sedition law itself impedes on multiple human rights such as freedom of expression, the freedom of association and assembly, and the right to a fair trial. International law is crystal clear. Criticism of the government and its institutions, even harsh criticism, is protected form of expression.